But Carl is here. We're opening up the legal line, 502-267-2422. You talk about injuries. We have an email here, and we want to take your phone calls when you call in. But Steve from Louisville sent you one. This is regarding an injury and a workers' comp question. Why are workers' comp laws so strict? A friend of mine hurt their foot on the job, and it was ruled only 50% the fault of the employer. Doesn't seem right. Steve in Louisville. What about that one, Carl?
Yeah, workers' comp laws are kind of a trade-off because in exchange, first of all, fault doesn't matter. The email mentioned about being 50% at fault. Fault does not matter. It does not matter if it's the employer's fault. You know, clients will say, well, can't I, my company took this guard off the machine, can't I sue them? And the answer is no. You cannot sue your employer for negligence. If they took a guard off a machine, or they said, this is, and you said, hey boss, this is dangerous, and he says, do it anyway or you're fired, well, that's basically too bad, because under workers' compensation laws, you cannot sue your employer for negligence. But if you do something wrong, let's say you're the employee and you weren't paying attention and you stuck your hand somewhere it wasn't supposed to, or you did something you weren't supposed to, it doesn't matter whose fault it is. As long as you're hurt during the course and scope of your employment, you get your medical bills paid. And but the downside is that as far as any final recovery, it's very minimal compared to what you could recover, say, in a negligence claim, which is where you get pain and suffering, loss of earning capacity. And workers' compensation laws are the benefits. I mean, while you're off work, you get paid 66 2/3% of your wage. But as far as any settlement, it's really not very good. And Kentucky is really considered pretty decent. Indiana is one of the worst in the country.
Well, Carl, we have another one from Casey in Salem. We're taking your phone calls and your emails. We appreciate them. You can email us anytime here on WBKI live at cwlouisville.com. But Casey in Salem, another workers' comp one. How do you know if you're eligible to get workers' comp if you're hurt on the job? Who decides the fault? What if there is a dispute? And this goes to what you're talking about.
Right. Same type of question where it really does not matter whose fault it is. So there's no determination of fault. The only, of course, you want to promptly notify your employer. You need to notify them right away, because if you don't and time goes on and they say, well, we didn't get a chance to investigate that, you didn't tell us in time, then that could jeopardize your claim. So it's important to notify your employer right away, and your employer is required to file what's called an employer's first report of injury. But again, fault doesn't matter. It doesn't matter whose fault, if the company did something wrong or if you did something wrong. That's not even a question.
And I know several years ago, I was working with someone. They were hurt on the job. They turned in a workers' comp claim to their employer, that first report in there. They never had to go to the doctor. I guess they worked it out in some way. But just because you turn it in, you may not have to go to the doctor, but it's good to get that paperwork into your employer.
That's right, because if you have to go to a doctor later, then without that documentation, then, I mean, I've seen cases where the employer says, well, I don't think you really got hurt at work. I think you were fixing your car at home and got hurt. So it's important to have that documentation to back you up.
We're talking with Karl Truman, 1-800-ACCIDENT is his number. You can give us a call here too. And you mentioned Indiana versus Kentucky law a minute ago, but what about payment on medical claims when you talk about workers' comp? We have a number of things up here, but what about payment of medical claims?
Well, and this is a huge difference in this between Indiana and Kentucky, because again, Indiana, some rankings that I've seen have put Indiana 48th out of 50th in benefits for the employer. Although I've heard some employers say that, well, they think that Indiana's ranked number 2 in the nation for benefits. But from an employee, a worker's perspective, it's really pretty horrible. And you get into the distinction between, well, if company was in Indiana and then you come over to Kentucky and get hurt, okay, where's the jurisdiction? We always try to look to file claims in Kentucky whenever possible, because Kentucky is actually pretty decent. The big difference is that in Indiana, your employer, your insurance company, the employer's insurance company, they have the exclusive right to pick your doctor. So if they say, we want you to go to the company doctor, you have no choice. Where in Kentucky, under Kentucky law, you get to pick your treating doctor. And I think that's very important, because I think that just common sense, that if you have confidence in your doctor, if you have faith that your doctor is looking out for you and not looking out for the company, you're going to heal better, you're going to improve faster. you're going to respond better.
And what I was going to say is that's why he practices law in both Kentucky and Indiana. He knows the laws. He knows it from A to Z. You want to give him a call, 1-800-ACCIDENT. And we are taking calls today. We have one from Robert in Jamestown, a question with the WBKI legal line this morning. Good morning, Robert.
Good morning. My doctor put me on light duty, and I worked for a couple weeks on light duty, and then the company laid me off. Was I eligible for unemployment after that?
Yeah, workers' comp, of course, it's a totally separate law from unemployment. So if you are willing and able to go to work, then yes, you should be able to get unemployment. So it's two distinct set of laws. The problem that someone run into, though, is when I've seen situations where someone is unable to work. Let's say the doctor said no work, and then they get laid off, and then you have trouble getting up for unemployment, because then you have to tell unemployment, yes, I'm ready and I can go to work. So it's kind of like conflicting there. You know, you can't be off work totally and then apply. But if you're, even if it's with restrictions, I've had clients, you know, that were in that situation, and they said, well, can I get unemployment? And I said, well, you are willing and able to go to work, but you need restrictions. So I think the answer is yes.
And Robert, if you need more information, do call 1-800-ACCIDENT, the Truman Law Office, and he or one of his associates can help you if you need a little bit more information. But we appreciate your call, and unfortunately, we get going with emails and calls, and we're out of time. But Karl is here every Tuesday with a legal line right here on WBKI Louisville Live this morning. Good having you with us, and have a good rest of the week. It's a short work week.
That's great. Thank you.
Thank you, Karl.